The next matter on our calendar this morning is the State of Utah versus Cassie Tolman. As soon as Ms. Klosnick is done pouring her water, counsel, could you please enter your appearances for the record?
Lila Mahmood for appellant Cassie Tolman.
Wendy Brown, co-counsel.
Karen Klosnick for the state.
Thank you. It appears, Ms. Mahmood, that you are going to reserve 3 minutes for rebuttal. Do you have any questions about how this morning is going to go? I might have questions about how this morning is going to go from my perspective, but
I don't have any questions at this time. Thank you, Your Honor.
just a reminder that when you do take the podium, please enter your appearance again because of the streaming. And you can begin anytime.
May it please the court. Lila Mahmood for appellant Cassie Tolman. This is a case where the jury was tasked with deciding who was telling the truth, Cassie or her children. But each of the errors in this case made it more unlikely that the jury would believe Cassie. These errors were that the trial court erred in granting the state's motion for the children to testify remotely under Rule 15.5, that counsel was ineffective for failing to object to inadmissible 404B evidence, and that counsel was ineffective for failing to object to hearsay that resulted in improper witness bolstering. Each of these warrant reversal. The trial court erred when it granted the state's motion for the children to testify remotely under Rule 15.5, and that error harmed Cassie. Under Rule 15.5, the state was required to show that the children would suffer serious emotional or mental strain or would testify unreliably if they had to testify in front of Cassie. The state did not show that here. Instead, what the state did is it assumed the children would qualify under the rule, and the trial court granted the state's motion based on that assumption. All the state said was that the children were the right age, that they were having trouble with this experience, and that Cassie was their mother. It was required to show more than this under the rule, and it failed to do so.
The state didn't have to put on a therapist or expert testimony about the children's mental issues, right?
No, so they wouldn't have had to put on an expert testimony. We know that from State v. Forbush. But there, what happened in State v. Forbush was that there was a pretrial evidentiary hearing where the state put on a close family relative, the grandmother, who was able to offer testimony about how the children would react if they had to testify in front of the defendant. That did not happen here. All that happened was the state said a few lines about how the children were the right age, and they thought that the children would be more comfortable if they could testify in a more intimate setting. That is not what it was required to show under the rule. It was required to show more.
The state's telling us that under Burt versus Tilo, State versus Litherland, and all these cases, that silence goes against the defendant, and that we should just presume that the state could have made the showing anyway. Why are they wrong there?
They're wrong here because, first, counsel did object. Counsel objected to this motion. But by making the motion for Rule 15.5, the state implicated Cassie's right to confrontation. There's a helpful quote from State v. Forbush from footnote 11 that kind of helps us understand the relationship between the Confrontation Clause and Rule 15.5 here. From footnote 11, it says, if a court makes the requisite determination under Rule 15.5, its decision to allow the children to testify remotely does not violate the Sixth Amendment Confrontation Clause. Here, the inverse is true. The state did not make the required showing, so the consequence is that Cassie's right to confrontation was violated.
Was counsel's objection to the concept of the remote testimony, or was it focused on counsel's inability to confer in real time with Cassie?
Counsel's objection was related to more of what Your Honor just said. But here, her right to confrontation was implicated when the state made the motion. Just like that quote in State v. Forbush outlines, when the requirements under the rule are not met, the outcome is that her right to confrontation is violated. Because Rule 15.5 is a carve-out from the Confrontation Clause that's only permitted if the state is able to make this, if the state does make this showing, and here they didn't do that. This also prejudiced Cassie, and here we can show this in 3 different ways. The first way is that before Cassie was even able to tell her story, the jury saw that she was removed from her children. There's a reasonable likelihood that this influenced the jury to believe that before she was even able to tell her story, she must have done something so horrible to her children that they couldn't testify in front of her. The second way that this prejudiced Cassie is
Well,
that...
except the court covered that with the explanation about, under our rule, this is an appropriate procedure.
So that is what the court said. It said under this rule, it's an appropriate procedure, but it didn't explain more. It didn't give any kind of limiting instruction that you shouldn't make an inference based off of what the rule permits in this case. It simply just said the rules allow this, and that wasn't curative enough in order to cure this improper influence that the jury might have had.
Although, if I'm a juror and the court just says, this is what our rules contemplate, I'm going to have a much different reaction than if the court says, now you're to read nothing into this. You're not to draw any undue inference. You're not in any way to hold this against Ms. Tolman. I mean, that seems to be more problematic than the court just matter-of-factly saying, this is consistent with our rules. And if I'm a juror, I shrug and I'm prepared to listen. Whereas if I'm given the more advanced treatment and told not to draw adverse inferences and so on, now I'm more focused on it than I otherwise would be, I think.
And I think what's important to outline here is that when we go back to the rule, this actually wasn't permitted under the rule because the state didn't make the correct showing. So the court just saying this is permitted under the rule wasn't curative and also wasn't accurate because the state was required to make the showing before the court granted the motion, so it wasn't actually even permitted under the rule.
But if the court is left with the impression, defense counsel has no objection provided that there's a way that I can ensure more or less real-time communication between attorney and client, it's not obvious to me that the court knew this was not agreeable to both sides, so long as the consultation piece can be addressed.
And I think here, this is where our ineffective assistance of counsel claim also comes in. So we raise this as a trial court error. We believe that this is a preserved confrontation error. We also believe that there is a preserved trial court error here, but we also raise this as an ineffective assistance of counsel claim for counsel making that later stipulation. Counsel here didn't stipulate to the children testifying under the rule, but he did stipulate to the children testifying remotely. That was objectively unreasonable here for 2 reasons. First, without that requisite finding under the rule, we don't get to remote testimony. So it's the same argument as before. The state has to make the showing in order for us to get to remote testimony. But also, Rule 15.5 lays out specific requirements under the rule, and our argument is that this remote outcome that we have here doesn't similarly follow the requirements under the rule. The first way that happens is that Cassie was removed from the jury for the testimony of all 3 children. The testimony of all 3 children is more than 3.5 hours of the trial. They are the bulk of the witnesses that the state calls. She was removed and put in a kiosk on a different floor of the courthouse for the entirety of that testimony, and for a good chunk of that testimony, she had her camera turned off and she was muted by the court.
I thought the camera being off was a comparatively small period of that 3.5 hours.
It's unclear how long that 3.5 hours the camera was turned off. We do know that it happens during daughter's testimony. But not even the rule contemplates removing the defendant from the jury. This rule is all about removing the children from the defendant. And here...
Not to cut you off, but I'm going to. At the 1,000-foot level, I don't know what to do with this for prejudice purposes, and let me tell you why. Prejudice case law talks about counterfactuals and hypotheticals, and in my mind, the sort of like frontline question on a prejudice inquiry is, all right, if we pretend that this thing didn't happen and instead went the way that you're talking it should have gone, what does this look like? What's different? And okay, so if the 15.5 objection is made differently, and suppose that the court says, you know what, you're right, I don't think 15.5 is satisfied, and now the kids are testifying in front of mom. I don't know what to do. I just don't know what to do. Like, what way does that cut? And I can see that going both ways. On the one hand, maybe testifying in front of mom makes them more reticent to talk. Maybe it makes them give more defense favorable testimony. But on the other hand, maybe it makes them break down and say, start crying and then blurt out, and I saw mom do this. And I just don't know how I'm supposed to figure this out. But it feels like you at least start with the burden of showing prejudice, particularly if we're looking at it through the ineffective assistance lens. And I just don't know. I don't know how I'm supposed to figure out that this helps your client as opposed to hurts. I'm wondering if you can react to that.
Yeah, so I'll root some prejudice argument in the facts. So we have that the jury saw that Cassie was removed during her children's testimony. That there's a reasonable likelihood that influenced the jury. We also see that Cassie was removed from the jury during the children's testimony. That affects the jury's ability to make credibility determinations about her, especially in a case where it's a he said, she said, and the jury is asked to believe one story over the other. Credibility determinations are so important here. And the final way was Cassie and counsel's inability to communicate with each other as much as they wanted to. Because she was removed and put in a kiosk on a different floor, whenever counsel wanted to communicate with her, he had to request time to communicate with her, run out of the courtroom, run downstairs, confer with her, and come back upstairs. And because for periods of time Cassie's camera was turned off and she was muted, the way that she was able to communicate with people in the courtroom would have been through this WebEx interface, and she wasn't able to do that because of being muted and having her camera turned off. So those are the ways that are kind of rooted in the facts that we can show prejudice here.
Aside from prejudice, even as concerns deficient performance on the part of defense counsel, under Strickland, if we can conceive of a reasonable explanation for the behavior, we're supposed to assume that's what happened. Why couldn't reasonable counsel here have concluded, you know what? The last thing I need is these kids in the courtroom looking at their mom, crying, emotional, freaking out from time to time. I don't want to say that with mommy here. I mean, it seems to me like defense counsel could say, I think it's in my client's best interest to make this as pristine an exercise as possible. Let's have the kids and mom elsewhere. I think my client is better off that way. That does not strike me as being clearly unreasonable, which I think means that under Strickland, that's a sound strategy that I can conceive of for why counsel, even though counsel might have preferred to argue the inapplicability of the rule, might instead just, you know what? The court has said this is the procedure. I'm going to play along because I think my client is better served by having that testimony come in remotely than in the courtroom here, where it may be much more emotionally charged.
And my response to that is that under Rule 15.5, the state has the burden. So here we have a preserved rule violation. The state made a motion under Rule 15.5 to have the children testify remotely. They were required to show that the children would suffer severe emotional distress, and then the court had to rule on that motion. Here we have a preserved trial rule error.
Well, preserved by the other side's bringing it up, not preserved by any objection made by defense counsel.
That's right, because it was preserved from the state raising it. And by the state raising it, it then implicated Cassie's constitutional rights to confrontation. So only to the point of counsel stipulating to the remote testimony do we then have the ineffective assistance of counsel claim.
Can you, just logistically, two questions. After the state made the motion, the court took counsel back into chambers to talk about logistics, but at that point, she hadn't ruled on the motion. Do we have any indication of what happened in that chamber conversation?
We do, because when the court came back, they made a record of what was talked about in chambers.
Okay.
And what was talked about in chambers was not why she's granting the rule, but
Right.
rather the logistics surrounding granting the rule. And what she said when she came back was that I'm going to grant the rule for the children at these ages under, I'm going to grant the state's motion for the children these ages under the rule. She doesn't say anything more.
And the kids were in the courtroom when they testified.
So there was a different setup
There was a different setup for the two
the different
younger
children,
ones,
yeah.
right?
So the older son was in the courtroom and Cassie was removed and put into a kiosk. For the two younger children, they were in a different courtroom from the jury with the judge and the attorneys. So we have two different remote setups
Two
here.
different, okay.
Yeah.
That's what that's.
Without any particular explanation for why the two different formats.
Yeah, there's not a specific explanation for the different formats. I think the state does say older son feels comfortable testifying in the courtroom with these other people, and that's why we're doing it this way.
Okay.
Yeah.
I know we're at zeros, but I did want to ask you just a question or two about the hearsay issue with the detective. And
Sure.
Here's the question I wanted to ask. We're now back to the sort of the bogeyman in the room, which is ineffective assistance and prejudice and presumptions and all that. But we're told we have to think about counterfactuals. And in my mind, if defense counsel makes the hearsay objection that you're saying defense counsel should have made, in other words, if defense counsel says, hey, the detective doesn't get to sort of compare and contrast the CJC interviews with the testimony, what would have stopped the state from then simply playing the CJC interviews?
So I'll answer that in a couple different
And
ways.
let me go ahead and ask the second question.
Sure.
And then just have at all of it.
Okay.
What would have stopped the state, number one, what would have stopped the state from playing the CJC interviews? And two, if it's possible that the state's response to the hearsay objection would have been, all right, fine, we're just gonna play the interviews.
Yeah.
Why couldn't defense counsel have said, I don't wanna make a hearsay objection, because that's what that's gonna cause them to do, and I don't really want the jury seeing these interviews. So I get why they make the relevancy objection they made, but it feels to me like it would be a little bit problematic for defense counsel to sort of nudge the state on hearsay grounds if the response is gonna be getting videos in that they don't really want the jury to see. So
Yeah.
react to that.
Okay, so first, at this point, Rule 15.5A governs how this kind of previously recorded video can be admitted at trial. And at this point, when officer was testifying, there were requirements under the rule that hadn't been yet met in order for the CJC video to be admitted. That is specifically that the court was required to make determinations of the reliability of the video before it could be shown to the jury.
They
And that
didn't do
hadn't
that?
happened. That hadn't happened yet at this trial. Because the CJC video, it's clear the state didn't intend to admit it, so they didn't go through the proper process for admitting it. My second response to this is that having the CJC video admitted would have actually been less prejudicial than officer testifying about it. Because here, the jury heard an officer, a person with authority, testify about what he thought the children's testimony was like, if it was consistent or inconsistent with their previous testimony. And that's the prejudice here, is that the jury heard somebody with authority that we know that juries are more likely to believe, say that he thought the testimony was consistent or inconsistent. So admitting the CJ...
I take the point, you're right, the consistency piece helps, getting that backwards. But on the flip side, correct me if I'm wrong, but both of the other two kids said things in the CJC interviews that were at least somewhat damning to your client, right? And it's more contemporaneous with the events, and so why can't, this is back to my original question, why can't defense counsel think, I don't really want the jury seeing the video that was taken so close to the events in question, in which, like, it's like a reiteration of the bad stuff. So
Yeah.
let's just let the detective say the handful of things about, oh, it's consistent, and call it good, right?
I guess I'll just respond with how I responded initially, that at this point, the CJC video wouldn't have been able to be admissible at the trial, and the state didn't go through the process to admit it.
But if called upon to do so, they come in all the time. The threshold for admitting them, the reliability of those interviews at this point, the bugs seem to have been worked out. And those CJC interview videos come in almost as a matter of routine. So I'm not impressed that it would have been quite the challenge for the state if the relevance / hearsay objection were thought to be well taken by the court. Those videos wouldn't have come in. It's not an onerous showing that would have to have been made.
And I think my response there is that, We're not sure why the state didn't choose to admit the CJC videos. What they did instead is they put officer on the stand to testify about them. It's clear to us that counsel didn't want officer's testimony to come in because he made an relevance objection 3 times. If counsel actually wanted to have a chance of excluding this testimony, the objection he should have made was a hearsay objection, and it was objectively unreasonable to make a relevance objection that the court was already overruling instead of a hearsay objection which had a chance of excluding the testimony he wanted excluded.
In that format, but
Right.
potentially more damaging testimony would very likely to have come in, as explained by Judge Tenney.
I think I'll just respond to the potentially more damaging. Here we have an officer telling the jury that he thinks the children's testimony is consistent or inconsistent or more believable or less believable. And we know that juries are influenced when they hear officers testify about this kind of things. So the prejudice there is high. Hearing an officer testify about what his opinion of the children's testimony is still very prejudicial.
But it might be even worse for the jury to see the more contemporaneous account of the interviews from the CJC. I mean, it seems to me like counsel could make that decision within the range of professional competence. Better this cop for a few minutes than an hour and a half or however long it was of the 3 interviews that were closer in time. This is a little more sanitized. I'd rather the jury heard that, even though it's technically a bolstering exercise. I'd rather have the jury hear that than the live accounts, the more or less contemporaneous accounts, I should say.
I think what we can infer here from counsel's objection is that his trial strategy was to try to keep the testimony out through his relevance objection. But we know that the relevance objection was not successful. And the testimony that would have made the state do more work would have been a hearsay objection, because this was hearsay that didn't fall into an exception or a non-hearsay purpose. And it would have excluded officer's testimony in this way. If there's no other questions, I ask that the court reverse Ms. Tolman's convictions and remand for a new trial. Thank you.
May it please the court, counsel, Karen Kluznik for the state. I'm going to start with the hearsay issue. And I'm going to add a little more information to the analysis. And that is that defense counsel could very well reasonably have concluded that a hearsay objection wouldn't work in the first place. And we know that because the children were asked about the CJC interviews during their testimony. And, okay, they were asked about them in their testimony. The 2 younger kids couldn't remember what they said. Okay, so
But why wasn't the state planning on putting them in all along? I mean, that's a little bit of a curiosity in this case, and that's something that counsel's alluded to, is it doesn't look on this record like the state was planning on putting the CJC interviews in. Or do I have that wrong?
as far as I know, there's nothing in the record saying that the state would. But the state doesn't have to disclose rebuttal evidence either. So I don't think you can go through that. It's quite possible the state and defense counsel sort of might have even agreed that instead of doing that,
But that would run into the fact that defense counsel made the
The
relevancy
relevancy,
objection.
right.
So, I mean, that's one of their key points too, is the record's not silent about whether defense counsel wanted these in or not. Defense counsel was trying to keep them out.
okay, so I disagree with that. I disagree that he necessarily wanted to keep just the police officer's testimony out. A relevance argument at least potentially would go to both the testimony and the CJC interviews. Hearsay would just go to the detective's testimony. But again, another reason why defense counsel might not have raised a hearsay objection is because it was admissible under the hearsay rules. We have the children saying, we don't remember what we said. And we have defense counsel repeatedly asking the children whether anybody talked to them before the trial. So both of those would support the substantive admission of the children's prior statements.
Because there
Whether-
was the part of the defense was these kids have been influenced by other people, right?
Right, and I want to make this clear. If they're influenced by other people, you have to show that the statements were made before the influence, right?
Right.
But I think it's Green makes clear it can be anywhere along the point where the influence supposedly took place. There's no question that the CJC interviews happened after the son talked to the grandparents. But defense counsel at trial was also asking before trial, between the CJC and the trial.
Which was a period of some 4 years, right?
Three, I believe, yes.
Okay.
Right. And that under Green, and again, I think it's Green, reopens the door to the prior consistent statements. So that's another reason why defense counsel might not object. And all of this goes to the fact that the record is completely inadequate to show ineffective assistance of counsel. You have to assume everything in defense counsel's favor. And we know that because that's what Litherland says. We know that because that's what Titlow says. So defendant has an opportunity to correct all those possible, mistakes, inferential mistakes through 23B. Defendant did not do that. So you can't, I would argue, under Strickland, reverse when defense counsel could.
So the 23B here on this issue would have said what? Make sure I've got this right.
I didn't want the CJC interviews to come in. It could easily say that.
It feels like, and this is an issue, this has come up in several appeals that I've been on in the last couple of years. And it feels like the state's institutional view of late, last couple of years really, has been that a defendant just has an affirmative obligation to file a 23B with respect to every ineffective assistance claim. And not just to file a 23B motion, but to file a 23B motion that preemptively whacks down any hypothetical reasons the state might come up with. Is that the state's view? I don't want to put words in your mouth, but that feels like where we're at.
It largely is the state's view because that's what Strickland and its progeny require.
So the case
I disagree with that. Strickland and its progeny speak in terms of not getting to the bottom of what defense counsel was actually thinking, but a much more objective view. If the court can conceive of a sound strategy that counsel might have had in mind, we're done. Mm-hmm. We don't need to ferret out and see what counsel really was thinking and really doing. Under Strickland, it's a more objective exercise on the part of the court. Well, it doesn't seem like the best way to go, but we can think of a sound strategy that counsel would have had in mind. And if we get that far, the ineffective assistance claim dies right there.
Right. I completely agree. But I think my statement was you cannot find ineffective assistance of counsel. You can find effective assistance of counsel because all the presumptions are in favor of finding effective assistance.
Are there limitations on how far down the road the court can go in its assumptions? And let me ask it this way. I mean, it feels like what the state has been saying in these cases is, well, defense counsel might have thought of A, mm-hmm. or they might have thought of B, and they might have thought of C. And if the defendant doesn't affirmatively and proactively file a 23B saying it wasn't A and it wasn't B and it wasn't C, then you just assume that and we're done. But then I think we're then in the world in which the state would say, yeah, but what about D, E, and F? And I feel like we reach a point of sort of analytical absurdity almost if you just keep going down the road of like how much do they have to preemptively think of and how much do they have to put in this 23B that they have to file conjunction with every ineffective assistance claim. And I just don't know what to do with this, because this keeps coming up, and I don't know that we've got the Utah Supreme Court having weighed in on it, and I don't know that we've really wrapped our arms around it. And I feel like it's just lurking in all of these cases, and I don't quite know what to do with it.
With all candor, I think this court is hesitant to impose the burden that Strickland defines. Strickland is a difficult test. You have to affirmatively prove these things. You just can't, they can't be inferred from the evidence.
Yeah, but the state can always come up with something, and I mean, the state could always come up with, well, it could have been A, it could have been B, it could have been C, it could have been D. And if we were to ever say the thing in the terms that I think you're asking us to say it, now a defendant who wants to make an ineffective assistance claim is going to have to sit around a table and come up with everything that they could conceivably come up with and file a 20, 30, 40-page 23B motion with respect, or in conjunction with every ineffective assistance claim. I mean, is that really the territory that we're in? And maybe your answer is yes, but I'm just trying to make sure I understand like where we're at with this.
I have two responses. I completely agree that at some point it becomes ridiculous, right? I am not arguing that every possible, no matter how many steps away from the evidence it is, that's not my argument. But my argument is reasonable. If you can come up with reasonable reasons why counsel didn't do something, defendant's claim loses unless he presents evidence otherwise. And that is Strickland. And I think Dunn v. Reeves says this. Titlow says no evidence. I think it's Dunn v. Reeves that says, you got to be really suspicious if defendant doesn't present defense counsel's testimony.
I mean, but to bring it back to the case we're talking about now and the issue that you were talking about, I think what you said a few minutes ago was that on the hearsay issue, that it's possible the defense counsel and the prosecutor just said, hey, there's no hearsay problem. Mm-hmm. And it just feels like we would just be making that up out of whole cloth.
Which you have to do because defendant hasn't presented any evidence. And let me go back to Reeves.
Yeah.
Dunn v. Reeves. And again, I think that's the right case. The Supreme Court specifically says defense counsel might have done this. They might have done that. They might have done the other, and they might have done the fourth thing. That's what the Supreme Court says. So yes, that is what defendant has to disprove. It's a heavy burden. It's intended to be a heavy burden. No two defense counsel would probably defend a case in the same way. And the purpose of ineffective assistance is not to come up on appeal and say, you know what, I would have done it this way. That's not the purpose. The purpose is to show that no competent attorney would have done this.
Right.
The defendant cannot do that on this record.
And that way, and it may or may not be this case, in fact, I doubt that it is, but for purposes of this debate, under Strickland, if we determined defense counsel did something very harebrained here, or seemingly harebrained, and try as we might, we can conceive of no sound strategy that would be served by that. We can reverse on ineffective assistance grounds if we're unable to conceive, as contemplated by Strickland, of any competent strategy that might have been served. And a case that comes to mind that I wrote many years ago, State versus Maritsky. Counsel failed to consider the pocket part. And so the jury was instructed in accordance with the older, lesser standard of defensive habitation. We couldn't think of any sound purpose that would have been served by having the jury instructed on a standard that was less helpful to the defendant. So we reversed.
Right. And
there are cases that are that clear. Now, they're few and far between,
yes,
because Strickland does invite us to just indulge the presumption that what the defense counsel knew what defense counsel was doing. So if we can conceive of any tactical basis that counsel might have had in mind, whether counsel did or didn't, we're obliged to conclude there was no ineffective assistance shown.
I have two actual responses to that. One is, I think you are absolutely right, and Massaro says that. Trial court records are not designed to provide the evidence necessary to decide ineffective assistance of counsel claims, so they will rarely be able to be decided on a trial court record. But rarely doesn't mean never, right? So your example, the example that I use is, a clear Miranda violation and defense counsel doesn't object to, a devastating confession.
That's a good example.
I think the state would have a difficult time opposing that. But not when there are possible reasons, and Massaro says, even if it, in an unusual circumstance where you can't come up with a reason, that does not necessarily mean it's ineffective assistance of counsel, because we have no idea what counsel was thinking. And you know what? If he can explain it, it might make sense. Again, the point is it hard? Yes, and it's intended to be hard.
But it's not intended to be impossible.
Possible, and we don't know what the 23B would have brought up, right? Defendant might be able to prove it on a 23B. They haven't taken that route, so this court must assume they could not. That's what Litherland says.
Can I take you to the 15.5 issue?
Yes.
Let me make sure I've got the sequence right before I ask the question, and I might have the sequence wrong, so feel free to tell me if I've got it wrong. The state makes the 15.5 motion. The defense objects to the remote testimony aspect of it. Court goes the state's way on that. And then defense counsel then ends up stipulating to the WebEx format. Do I have that sequencing right?
I don't agree.
Okay, yeah, go ahead. What part of that did I get wrong?
I mean, that's the timing, except I disagree that counsel objected. Defendant essentially admits that confrontation clause objections were nowhere to be seen here.
But they object to at least the 15.5
They object to
aspect of it.
logistics, right? The concerns are, she's not going to be in the same room with me for cross, so that we can decide. And the jury isn't going to be able to see the witnesses. Okay, well, the witnesses are taken care of with the video screen. And defense counsel, they come to a decision, they stipulate, that's what the,
So your view of the record, okay, this is clicking in place. Your view of the record is that they never really objected to 15.5 at all. They're just talking about the mechanics of it.
right.
Okay.
And they certainly never suggested that the state could not prove that the children would suffer substantial emotional harm. And I know my time is up. The idea that,
So let me just pause you before you go to I know that your time is up part. So you're saying if they're not making the 15.5 objection at all, then the court's not even really being prompted to make the particularized, individualized findings, right? And that's why that's not a problem, is because the court wasn't even asked to, really.
the court was not asked, right? And I want to, there was a stipulation, a supplementation of the record on appeal about the off-record discussion, and it was filed.
But doesn't the court have an independent obligation to make those findings anyway?
No.
15.5B says upon motion of a party and for good cause shown. And the good cause shown is, as I understand it, is where we draw those requirements from. And so doesn't that contemplate that once the party makes the motion, the court's still got to make the good cause finding?
No. Defendants can stipulate to a lot of things, right? They can stipulate to, they can stipulate to children.
Right, but stipulating is different than not objecting. Right, I mean, the stipulation is an affirmative waiver, and not objecting is just passive forfeiture. And the rule is saying that 15.5B gets invoked upon motion of a party and for good cause shown. And so does the court so the state stands up and says, we want to do this remotely, doesn't the court still, I don't mean this to be a gotcha question, I'm just thinking this through. Doesn't the court at that point have an obligation to just go ahead and make the findings? Or are you saying the court at that point doesn't have to make the findings unless prompted to do so?
Well, I'm going to ask you a question in response.
I may duck it, but sure.
Court makes the findings, so the children cannot testify remotely.
Yeah.
Defense counsel says, what? What? You're gonna preclude me from making this strategic decision? No. I mean, that's why.
That's your point, right?
Is because the trial court has to tread lightly when possible strategic decisions are at issue.
So you're saying the non-objection is communicating to the district court that the defense is not opposed to this generally?
Yeah, and
And so then the court doesn't need to go through the step of making the good cause finding.
right. I mean, defense counsel never stipulated. But defense counsel also never said confrontation, right to face-to-face confrontation.
We need
The
a
state
showing
hasn't
under
made its-
15.5.
Yeah, the state hasn't made its necessary showing. Defense counsel never did that. They said, something like,
About credibility.
I understand what 15.5 allows. I just want to put on the record these two concerns. That doesn't sound like an objection to remote testimony to me. I also, and the idea that 15.5 objections preserve constitutional claims is really outside, is inconsistent with the preservation rules anyhow, because the preservation rules apply to constitutional claims. And, for example, defendants raise hearsay objections all the time. They are not preserving confrontation clause
But this is a
claims.
somewhat unique situation because 15.5 is so closely tied into the Constitution.
As is hearsay.
Fair, but they've quoted for us that footnote from Forbush in which it talks about 15.5 is the protection for this very particular right. And so if I'm a defense attorney and I'm sitting at table at trial and the state makes a 15.5 motion, it's probably baked into my brain that when I fight them on 15.5, I'm fighting them on this constitutional rights. That's the whole point of 15.5, right? Or am I overthinking?
I don't know if it's the whole purpose. I think it preceded Crawford, which, right, changed the whole confrontation landscape. But we have lots of evidentiary rules and statutes that protect constitutional rights, that codify constitutional rights. Objecting under them does not preserve a constitutional claim. That's just the way it is. Again, and hearsay's the most obvious one, right? One other thing about prejudice, as far as the hearsay goes, the CJC interviews are not in the record. Defendant cannot base a prejudice argument on the idea that the CJC interviews would have been less prejudicial. Again, defendant's obligation to affirmatively prove, and defendant hasn't provided this court with the evidence necessary to do that. Thank you. So the state would ask that you affirm.
I think I'd like to first start by addressing the state's argument that the court doesn't have to make a finding under Rule 15.5. Rule 15.5 requires the state to show that the children would suffer emotional distress and for the court to make a finding of the children's emotional distress for each child, which is, the court was required to make a finding for each child. That didn't happen here, and the state didn't make a showing of that kind of evidence.
What's your response to their argument, though, that once the state makes the motion and defense counsel doesn't make the particularized objection, then the district court isn't really put on notice that it needs to make that finding?
I think that's inconsistent with the language of the rule. The rule requires the court to make a finding that the children would suffer severe emotional distress or be able to testify unreliably. That language is in the rule. And only if that requisite finding has been made can the children testify remotely. It's right there in the rule, and to say that they don't have to do that is inconsistent with the rule.
So the court doesn't make the finding, but defendant doesn't object, which is what happened in this case, primarily. That's just a plain error on the part of the court.
We argue this in relation to a confrontation error because of that footnote 11 where it says it explains the relationship between confrontation and the rule. The court doesn't have to get to confrontation to still find for us because we have a rule error here that is preserved because the state made the motion. Our preservation rule here is to give the court an opportunity to rule on the motion. That happened here because the state made a motion under Rule 15.5. The burden was on the state to make that showing under the rule. They didn't do it, and the trial court granted the motion anyways, which was an error. And that's how we have a preserved rule error here as well. And we show traditional prejudice, which we talked about in our previous argument. I'd like to address the state's argument about 23B in relation to ineffective assistance of counsel. Requiring a 23B motion is not the standard under Strickland. Here we have a complete record, and we know from the record in relation to our ineffective assistance of counsel claim with the witness bolstering that it was counsel's strategy to try to get that testimony out. We know that because he made an objection, he just made the wrong one. He made a relevance objection when the proper objection would have been hearsay. The cases that the state cites, Dunn v. Reeves and Mazzaro, these are federal habeas cases that don't apply here. Our standard here that applies is Strickland, and under Strickland—
I'm not sure why that matters, though, because in the federal system, you file the 2255 petition after the criminal case is concluded. And so what the courts are saying is there's no record from the direct criminal case, and so you can do it through 2255, but that's the equivalent of state 23B. And I mean, this is really deep in the weeds, but I think that's why that plays out that way. I think what the state is saying is 23B is the mechanism in our state system for creating a record, which is equivalent to the 2255 mechanism in the federal system. So we're basically parallel.
But here we only require 23B if the record's not complete, and the record here is complete. We are able to see from the record that counsel was objectively unreasonable when he made these errors. When he made the error to object to relevance instead of hearsay. When he made the error to not object to impermissible 404B evidence when the state was able to discuss Cassie's prior 2017 conviction for child abuse, which the court had already ruled was prejudicial.
That is beyond the scope of your rebuttal. Ms. Klusman
I'm sorry.
didn't say anything about
Okay,
that.
you're right. For these reasons, we ask that the court reverse Cassie's convictions and remand for a new trial. Thank you.
Thank you, counsel, for your arguments today. Good to see you all. We will take this matter under advisement and render a written decision as soon as we can. And that concludes our arguments today, and we will be in recess.